Good Friday evening, everybody. Welcome back to Let's Talk Live here on the LTL Media channel. I hope everybody's comfortably seated this evening. We're going to get into the motion to dismiss today. Judge Bev made her ruling yesterday, and the document was released this morning. And I mean, come on. It's not a shocker. I don't think this was any news that anybody didn't think was coming. We knew this was coming. I think we were just preparing ourselves for it and just the anticipation, I guess, for the big letdown. But I wasn't really let down because I knew this was going to happen anyway. But it was just interesting to see a lot of the reactions. Obviously, we're all frustrated. We're all angry. We've talked about this close to a year now, the sham trial that Karen Read has been put through, exhausting her time, her resources, and Karen Read's factually innocent. I mean, it has been proven that she is factually innocent. So to keep going through this, keep bringing her through the ringer is just a complete, utter, just disgusted. I'm disgusted. It's just infringing on her rights as a human being, as someone out there in the world that did not do this crime at 34 Fairview. And, I think I just kind of wish that the Commonwealth would do a little bit more work here on capturing the real killers. And we know who those real killers are. They were the people that were inside 34 Fairview that night. And along with the massive police cover up and corruption in this case, it's almost spellbinding. So I just want to get up here and welcome everybody into the chat. Good to see everybody this evening. Let's just go back up to the top of the chat. And we'll make sure that 25% of all donations tonight go to the Karen Read Defense Fund. So we're going to start it off with $5. Kathy, thank you so much for becoming a new YouTube member. That helps support the channel here, keeps the lights on a monthly basis. So I appreciate that. Heather says Karen Read is not guilty. Another $5 donation. I really do appreciate that. And, like I said, that helps keep the lights on here in the studio. Good to see Sophie's here. One of my moderators is here. Lady Law Sandra, nice to see you. Good evening, Annie. Nice to see you. Peggy's in the house. Good to see you. Oh, Paul's here. Thank you. Good to see you as well. Yes, the ghost. No ghost tonight. I have a good vibe going on in the studio tonight. So I don't know. I think we're feeling pretty good. Lit for LTL's in the house. Nice to see you as well. Let's see. Can I still be upset tonight? You can be upset. We're going to get into it. I have a presentation put together. We're going to play some videos and go through all of that. And we'll talk about all this. And I'll try to break down and give my decipher, because I'm not a lawyer. I'm not a legal analyst. I'd love to hear what Mark Betterow had to say about this. He was tweeting about it this morning. And I actually covered that in my blog this morning about the motion to dismiss. But I'd love to see when he actually gets on one of these shows and talks about it. I have to go back. I know Melanie Little did something earlier today around noontime. I might go back and watch her stream and see what she had to say about it. But yeah, I mean, of course you can be upset. I mean, listen, we're all upset. We're all pissed off. Yeah, I mean, Aunt says, hey, exactly. I'm not surprised, but I'm still pissed. Of course, everybody's pissed off. But I'm going to tell you one thing. Karen Read's not going to fold. Karen Read's not going to give up. Defense team's not going to quit. The Free Karen Read movement is going to continue. We will continue to raise funds for her. We will continue to do standouts across Massachusetts, across the nation, across the world, to let everybody know what's going on here in the state of Massachusetts, the corruption. And we will continue to get the word out there. Believe me. Daffy, checking in. Good evening. Good to see you. Scott McGinnis says, hey, peeps, I'm out. Drop in like replay crew for me. Not a problem. Hope you're having a good night out. It's an embarrassment. It is an embarrassment. Lauren C. loves the hat. Yes, I got my BOMA hat in today, the all-black trucker hat with the Free Karen Read pass. And if you're patch, and if you're looking for a good hat, if I can get this to focus, let me see. You're looking for a good hat, check out BOMA hats on Etsy. I think I'm saying that right. BOMA hats, born in Boston, made in Colorado. Jennifer's a great supporter of the Free Karen Read movement, and 10% of all Free Karen Read hats go to the Karen Read Defense Fund. So I know she stocks, they go out quick. I try to promote them when they're up when she restocks, I try to drop her links to let everybody know and notify everybody that she is excuse me, she is restocked to go over and check out a hat. Okay, so let's do this. Let's do this. All right, so like I said, I have a presentation. We're going to talk a little bit about that. I'll bring that up here in a second. But let's go over first to ltlmedianews.com. If you're not checking it out, please do. That is my official website, and I did a short blog this morning, and I'll read through this, and then we'll get to the presentation, and we have some videos. We're gonna have fun. It's a Friday night. We're hanging out. We'll take our time and go through all of this tonight. And like I said, I'll try to break it down as best I can and let you know what I think is all going on. So Judge Cano rules on motion to dismiss counts 1 and 3 in Karen Read case. Denied. Judge Beverly Canone has rejected Karen Read's request to dismiss 2 charges against her. The judge stated that since Read was not acquitted and the mistrial was agreed upon by her defense, double jeopardy does not apply. The Norfolk County District Attorney's Office applied the judge's decision, noting it aligns with longstanding legal precedents and plans to proceed with the trial starting January 27th. Attorney and legal commentator of the Karen Read case, Mark Betterow, in a tweet Friday morning states, the Friday decision puts on the onus and pressure on the DA for now to deal with the fiasco created by the apparent literal fact that Karen Read was acquitted of murder. The charges are obviously flawed, and it is obviously overreached. And most importantly, every potential juror at possible retrial knows she was acquitted of 2 of the 3 counts. Is the DA foolish enough to face all of this with a straight face going forward? To do will be to sacrifice whatever credibility they have left in this matter. I love that tweet. That's why I want to add it to this article. Put the tweet over here to the right-hand side. It says, Mark has recently joined Aidan Turtleboy Carney's legal team to challenge the witness intimidation charges brought on by the Norfolk County DA Michael Morrissey. These charges stem from Carney's exercise of his First Amendment rights during a rolling rally in Canton, Mass. In 2023, where he voiced his concerns about the charges against Karen Read. As the legal battle continues, both sides will navigate a landscape shaped by legal precedents, public scrutiny, and strategic maneuvering. The coming months will be pivotal in determining the outcome of these intertwined cases and the broader implications for all parties involved. And of course, we will continue to fight and free Karen Read. And if you're not checking out my website, you can. And what I encourage everybody is on, let me see, just bring this back up really quick. On the landing page, hang on one second. I'll just give everybody a little update on my landing page. I worked on this today, but if you go over to the latest stories and news, you have all these tabs you can click into. Karen Read updates, Sandra Birchmore updates. Obviously, those are the 2 major cases that are going on right now. Some local news and national news. And then what I did today is I added another box where you can click to donate right to Karen Read's defense fund, because she needs us now more than anything. You can click right in that, and it goes right to her legal defense fund. So if anybody's asking like, hey, where I can get the link, just go to ltlmedianews.com, and the link is right on my landing page. All right, let's get into my presentation for the night. Let's see. If you all don't know, just to let everybody know that 25% of all donations tonight will go to Karen Read's defense fund. All right, let me get over and share my screen here, and we can go through this presentation and we'll get into it. All right, let's present full screen here. Hopefully everybody can see it. All right, let's go. So today, denied, judge rules in Read motion. Okay, so denied. And we have the end of the court document here, and I'll read this a little bit. Let me get my spectacles on here. And why we do this, let's see. So let's see. The court, in conclusion and order, this court recognizes that the bar on retrial follows acquittals is perhaps the most fundamental rule in history of double jeopardy jurisdiction. Taylor, 48 Mass at 48, quoting United States versus Martin, Linen Supply Company. However, where there is no acquittal on any of the charges in the defendant's first trial, there is no risk of subjecting the defendant to double jeopardy by retrial on all charges. Therefore, the defendant's motion is dismissed, of dismissal is denied. I mean, it's not anything that, I wouldn't say we're surprised. It just now concludes the absolute biasness in this case. I mean, we knew that all along, and we're going to see examples of it tonight when I play through some of this testimony, the biasness and, basically Bev being in with the Commonwealth. She's going to keep pushing this all the way. And I'm going to go into this here in my presentation. This is basically comes down to, they know, the Commonwealth knows, Adam Lally knows, Michael Morsi knows that they will never, ever find a jury that's going to convict Karen Read of anything. It's never going to happen. And I would even put forth that if this does go to trial, a second trial, she will be acquitted of all charges. But they know that they're never, ever, ever going to find a jury that's going to convict her. And even if it goes to a mistrial again, and they try again, and try again, and try again, and try again, it's always either going to be it's always going to continue to be a mistrial. They're never going to find a jury. Never, ever, ever. And right now they know that. So the only way that they can get Karen Read is to what? Keep dragging this out, bringing her into court, having to fly her attorneys in from all over the place, car service, bodyguards, whatever it may be, expenses. Let's drain her of her resources. Let's financially cripple her. And then maybe she won't be able to defend herself. Well, I got news for you. The Free Karen Read movement will always help, will always contribute until Karen Read walks out of that courtroom acquitted of all these bogus charges and can go on with her life. We won't quit. We have no quit. We're not going away. We're here, and we're here to stay. Let me just pull this up here. I have a $10 Aussie super chat. We'll add that $10 here. Says, knew it was coming, but never felt so disgusted as I do today. The tone of her writing and snark towards the defense attorneys was a disgrace. And that's a great point, John. We're going to talk about that tonight in my presentation. So I appreciate that. Thank you for pointing that out. All right, so we're at, right now, $20. So we're at another $10 into the fold. We're at 20 right now. And we'll just keep rolling on. And like I said, 25% of all donations tonight will get kicked back to Karen Read's defense fund. If you're just getting in here, please make sure to smash the like button. So just like John was saying, I think John knew that this was coming up. It says, Bev gets critical. And let me just increase this because I'm blind as a bat. I'm going to put on my spectacles here. So on what page was this? Page 14. Page 14. If you all read through the document here, Bev getting critical. Instead, defense counsel said nothing to the court about the mistrial and then proceeded to the courthouse steps. And she gets very critical about Alan Jackson. We know how Bev feels about Alan Jackson. We saw that through the entire trial. So instead, the defense counsel said that the court about the mistrial, then proceeded to the courthouse steps where Attorney Jackson declared the media and onlookers that the Commonwealth failed miserably and will continue to fail with its prosecution of the defendant. It strains credulity to believe that the defense counsel wanted to voice any objection to the court, it would not have been heard. Significantly, defense counsel were no shrinking violets. Neither Attorney Jackson nor Attorney Yannetti has ever needed this court to inquire whether counsel had the objection in the order to be heard, and that the court never denied counsel the opportunity to be heard in open court or at sidebar. Excuse me, take off my coat. So you may be asking yourself, what does this all mean? Well, obviously, she's for the Commonwealth. This is a bogus statement. I don't respect this judge at all. There's no grounds for a retrial here. And you're going to trust all of these witnesses to get up again. You're going to get up and have Trooper Proctor be a Commonwealth witness. You're going to have Jennifer McCabe be a Commonwealth witness. Commonwealth's not going to call Proctor. I'm going to tell you who will. The defense will. And it was funny. I was reading TB Turtle Boy's blog today, and he was talking about, asking about Jennifer McCabe to the juror that he spoke to. And they had their thoughts about how evasive she was, how they felt that she was very evasive. Just reshare my screen here. So we go on. So, no verdict. And this is Bev. Quote from Boston.com. Because there was no open and public verdict, affirm in the open court rendered in this case, the defendant was not acquitted of any charges. She wrote, the only unanimous act of the jury here was their representation to the court that they were at an impasse and unable to agree on whether the Commonwealth had established beyond a reasonable doubt the elements of the charges. So I started to think to myself, like, what could this all mean? What could this all mean about this mistrial? And I started to look around, gather some information, and try to interpretate, what Bev is saying here. So Bev's reasons, and I just want to read this Cash App that came in. I appreciate that. We're going to add that to the total. Let's see, $20 Cash App from Crystal. Thank you so much. We got $40 so far. And we will continue to move on. So here's my interpretation. So let me just put my spectacles back on here. So Bev's reasons, no open and public verdict. The judge is stating that there is no formal verdict given to an open court. Typically, a verdict is a form decision delivered publicly in a court. And in this case, there wasn't one. The defendant not acquitted. Because the jury did not render a formal verdict, the defendant was not officially acquitted of the charges. The acquittal would mean that the defendant was found not guilty and that it didn't happen here. Again, this is Bev's reasoning. This is where she's thinking. Unanimous act of the jury. The only thing that the juror agreed upon was that there was an impasse, meaning that they could not come to a consensus. They could not agree on whether the prosecution had proven the charges beyond a reasonable doubt. Impasse and reasonable doubt. The jury's declaration of being at an impasse indicates that they were stuck and could not agree on the evidence. This impasse means they could not decide if the prosecution has met its burden of proof. And that's what you have to remember in all of this. We're going to talk about it the second time around. What's going to happen the second time around? Well, that burden of proof is going to be greater this time around. Hang on one second. Excuse me. It's going to be greater this time for the prosecution. So again, Judge Bev is clarifying that since the jury did not deliver a formal verdict and instead reported they were deadlocked, the defendant wasn't officially acquitted or convicted. In her mind, in her ruling, the case was essentially unresolved due to the jurors' inability to reach a decision. All right, so the defense had its chance. That's what Judge Bev says. The defense had its chance. They had their chance. That's what she said in her motion, in her ruling today. And this from Boston.com. While Assistant District Attorney Adam Lally argued in favor for continued deliberations, Unetti asserted that the jurors had indicated that they were exhausted all manners of compromise and matter of persuasion, that they were at an impasse. When the jury came back on July 1st to say the consensus is still unattainable, Unetti again argued in favor of giving the Turi Ruiz instructions in the last-ditch effort to break the deadlock. In arguing for the so-called dynamite charge, the defense was presumably aware that a mistrial was likely outcome of the jury remained deadlocked, Canone asserted. Nevertheless, in the remark turnaround, defense counsel now argues that the result they were twice advocated for was sudden and unexpected. She wrote, According to Cano, Reed's lawyers had multiple opportunities to voice an objection if, in fact, had one, and could have asked to poll the jury immediately after the mistrial declaration. Quote, the court finds it hard to believe that the counsel heard that the jury was at an impasse for the third time and a mistrial was inevitable, perhaps the most critical point of the trial. Counsel would sit silently if they did not consent to a mistrial, she wrote. Reed's lawyers also suggested that questioning deadlocked jurors is common or best practice for trial judges. However, Cano argues that doing so could impede a defendant's strategic decision to either request polling or leave the final tally shrouded in mystery. The defendant arguments is biased on hindsight, she wrote. No one other than the jury knew the questioning the jurors as to their deadlock would have yielded favorable outcomes for the defendant. Just go up here and look in the chat really quick. Let's see. Heather Licious asking, Brian, is the ghost gone? $2. Yeah, I haven't had any issues tonight. Everything seems fine. I don't know. Maybe it was like a spiritual night or something the other night. I don't know. I have no idea. It was just weird. There's a lot of weird stuff going on. Just like this case, there's a lot of weird stuff going on. All right, let's talk about, the defense. Why didn't the defense stand up? Why didn't the defense say anything? Well, let's go into this. Bev's reason. So, I took all that information, tried to decipher it, came up with these conclusions. Defense aware that the mistrial likelihood. The judge noted that the defense, by advocating for the two reasons instruction or dynamic charge to break up the jury's deadlock, was likely aware that this could result in a mistrial if the jury remains unable to reach a consensus. Turnaround in defense argument. Despite previously pushing for a mistrial, the defense later claimed that the mistrial outcome was sudden and unexpected. The judge found this shift in argument to be notable. Number 3, opportunities to object. The judge pointed out that the Reed's lawyers had several opportunities to object to the mistrial declaration and could have requested to poll the jury immediately after the mistrial was declared. And I want to hang on that a little bit. Just keep that in mind, because in the next slide, we're going to talk a little bit about, maybe possibilities why the defense didn't say anything. Counsel's silence. And this is another one that I want you all to hang on. The judge expressed skepticism about why the defense counsel would remain silent when the jury was in an impasse for the third time, and the mistrial seemed imminent if you did not agree with the mistrial. Number 5, questioning deadlocked jurors. The judge acknowledged that while the defense argued that questioning deadlocked jurors is common practice, it might hinder strategic decisions. Specifically, questioning could either force a decision on polling or reveal the jury's final tally, which could be disadvantage to the defense. Number 6, hindsight criticism. The judge criticized the defense argument as being biased on hindsight, emphasizing that only the jury knew if the questioning them about the deadlock might have led to a more favorable outcome for the defense. And maybe everybody's just sitting here and saying, why? Why didn't the defense say anything? Well, could be some of these reasons. Again, I'm not a lawyer. I just did some researching today, put some things together, things that I agreed with, maybe some interpretations that I got out of all this ruling. And again, I'm waiting for, I'm going to go back and listen to Melanie Little. I want to hear Mark Bettero's take on it and go from there. So maybe it's a strategic advantage. The defense may believe that speaking could unintentionally sway the jury towards a verdict they don't want. Sometimes allowing the jury to deliberate without additional input could be beneficial, especially if the jury is leaning towards a not guilty verdict or is deadlocked in a way that benefits the defense. Excuse me. Avoiding a mistrial. Number 2, the jury's deadlock. The judge might declare a mistrial. The defense may choose silence to avoid any potential mistakes that could lead to an unfavorable outcome or to prevent the jury from becoming fully further influenced in a way that could not harm the defense case. And how many people in here with a raise of hands thought that jury was influenced in that room. I mean, there was reports that there was bullying going on. Oh, my voice cracked. Oh, there was bullying going on inside that deliberation room. I'm sure there was. I'm sure people were heavily convinced of Karen Read's innocence. I'm sure they were bullied in that room. Could there have been any outside influences that came into that jury room? We've heard reports of that. What do y'all think? Got some hands. So we have the legal strategy. There may be specific legal strategy or considerations that the defense is taking into account. They might be waiting for the judge's guidance or consideration the best time to make a strategic move based on how the deliberations are unfolding. And then number 5, preserving credibility. Sometimes the defense might want to preserve their credibility and avoid making arguments that could appear desperate or overly aggressive. Remaining silent can be the way to maintain a certain level of professionalism, respect towards the jury's process. I got to go with number 5. Respect it. It's the jury's decision. We'll fight it in motions going forward. We'll wait to see if people talk, and they did. And I think that if they would have went out and bitched on the record or whatever, or said anything right away, it may have held back jurors from talking. And then we found out. They reached out to the DA's office. They reached out to the defense. Seemed like at one point the defense was holding back that information. Jurors started to come forward and talk. Look, this is not the way it was in that room. Turtle Boy just got an exclusive interview. Fantastic. And now with all of this coming out in a possible retrial, I hope more jurors step forward. I hope more jurors go to the media. I hope more jurors go out there and put it on the record. This is not the way that it happened inside that jury room. This is how I was feeling. Karen Read is not guilty. All right, let's talk about some food for thought. We talked about this. As much as the Commonwealth will put, if they want to do this over and over and over and over again, Karen Read will never be convicted. So, and I talked about this earlier in the show, what are they going to try to do? They're going to try to bankrupt her. Let's beat her down financially. We know we're never going to get the criminal conviction. We'll deplete her of all her resources. And then maybe we get her to a point where she says mercy. It's not going to happen. I'm going to tell you why. Because she has thousands and thousands and thousands of people behind her, supporting her, contributing, doing their part. And she has a hell of an amazing spirit that's never going to break. You're not going to break her. It's not going to happen. She has tremendous resources behind her. So the Commonwealth can continue to waste their time, continue to waste taxpayers' money. You're never going to convict Karen Read of anything. Now that we're so public here, and we'll talk about number 2, now that this case is so public and all around the world, let's turn on my fan. I'm sweaty tonight. I'm amped. Now you go into how do we find an impartial jury? Everybody in the state of Massachusetts know about this case. I mean, there's not anywhere you can go. So what do you do? Change a venue? I don't even know. Could you bring this out of state? I don't think you can. I don't know. I may have some legal minds in the room can help me. But everybody but it was funny because, and I go back to this point that Mark Betterow made on my show, I don't know, about a week and a half ago. Said, even if this goes back to a trial and they need to pick a jury, or even if you just walk up to someone on the street and you say, Karen Read, and say, first thing that comes to your mind, what are they going to say? Oh, that's the woman that's being framed. You get my drift? That's the woman being framed. Let me just pull this donation up here. I had something come in from Buy Me a Coffee. I just want to make sure that that's out there in public. Again, 25% of all donations tonight will be donated back to Karen Read's Defense Fund. I'd love to get to at least $50 for Karen. Let's see. Carrie, thank you so much for the $5. So we'll add that to the total. If one of my moderators can add that, I think was at 52 the last time. And we'll just bring this up. Annie, thank you so much. $5 membership. So we'll add that to the total. So what was I at? 52 plus 5 plus 5. We're at 62. Great. Thank you, Sophie. Appreciate that. Okay. I talked about this on my show. Karen Read. They need Karen Read because this is so deep now to go down for this. She is the person. She is the one. And all below that is all of the corruption, all of the lies, the murder of John O'Keefe. Not by Karen Read, by the people at 34 Fairview that night. She is the one that's holding all of this together. If she falls, and we're slowly seeing it, Trooper Proctor, Tully, Buchanan, we're seeing stuff now in the Sandra Birchmore case that's coming out and being more public. Still an active FBI investigation. If Karen Read tumbles, all of that falls out. If she's pulled out of the equation, acquitted and pulled away, tumbles out of the situation, all of that bubbles to the top. And it's going to be like a volcano. It's going to burst. And it's going to look really bad. And Todd McGee sat in this chair, retired veteran, 24-year veteran of Massachusetts State Police. In his lips to God's ears, he said that there is more to come out. You will see more that will fall with all of these other officers involved. He said it. He said it. I have not talked about this. This is the first time on this show I'm saying it. He said there will be more people that go down with this, not just Proctor. Excuse me. Again, number 4, more fallout and corruption will be exposed. Erica, thank you so much for $20 on Venmo. I appreciate that. Trish, thanks for the $20 on Venmo. Says free Karen Read. I'll allow it. I love it. So let's add 40 to the total. Remember, we have the active FBI investigation that is ongoing. Has not ended. And then I'll do a bonus here. Number 6, more jurors are going to talk. And again, TB released an article on his website today. TB just spoke with a juror. We need them to speak. All right, so if we go forward with a retrial, if there is a retrial, I will give you my top 5 issues that the Commonwealth is going to have. Number 1, terrible witnesses for the Commonwealth. You think you're going to get Trooper Proctor back up there? You're going to get Tully up there? You're going to get Buchanan? You're going to get Jennifer McCabe, Brian Albert, Katie McLaughlin? You think you're going to get all of them back up there and spit all this nonsense back out for another jury? You're going to trust them? Look at the fallout with Proctor. You don't think that any person in Massachusetts doesn't know who Trooper Proctor is right now? If you say the name Trooper Proctor, I'm going to tell you right now, just like I said, if you say the name Karen Read, what will people say? Oh, that's the woman that's framed. What are they going to say if I say Trooper Proctor? Oh, that's that piece of shit that talked all that stuff about, nasty stuff about Karen Read. Called her all vile names. The C word. You don't think that that's going to not stick especially in a woman's head? You call a woman a C word, whew, yeah, that stays forever. That shit's like glue. That's going to stick forever. Then you look at the botched investigation. We had the leaf blower, red Solo cups, Stop and Shop paper bags. Todd McGee sat here the other day, about 2 weeks ago in my studio, and he said, I've never seen anything like that in an active investigation. When I actively investigate, we use uncontaminated evidence bags. We collect evidence. We go knock on doors. We talk to witnesses. We don't allow witnesses to walk away and go inside the house where someone was murdered to give those people a heads up. Sarah, thank you so much. $20 super sticker. I appreciate that. I really do appreciate that. And we'll get into the witnesses tonight. I'm going to play some of the witness testimony and say, you're going to bring these people back in, Adam Lally? You're going to let them testify for the Commonwealth? They can't even keep their fucking story straight. They need to refresh. Oh, I don't remember. I don't recall. Because you're lying. You're playing dumb. You know what happened? Oh, I don't recall. I don't remember. The standard quotes from the Commonwealth witnesses. We go to number 3, corrupt police, past and present. Tully, Proctor, Buchanan, Higgins, Brian Albert. Remember, Higgins and Brian Albert, what did they do? What was the common link between both of them? Excuse me. What was the common link between both of them? They both destroyed their phones. People that don't have anything to hide don't destroy their phones. They hand them over to law enforcement. They don't run off to a federal building and go, hey, and I'll pull all the information, the selective information that I want to turn over to the police department. I'm going to use a federal facility, a federal machine to go in and selectively pull off the data and then hand it to the police department because I don't want anybody else looking at the data on my phone. Well, why not? What do you got to hide? What are you hiding? And then after that, I'm going to destroy my phone. I mean, I don't know. That seems cover up to me. We go into the planted evidence, the tail light, the drinking glass pieces, the DNA evidence, the hair, John O'Keefe's hair, the Sally Port video that was tampered with and reversed and up and down and left and right. Excuse me. And then we talk about the Commonwealth's experts. Oh boy, those experts like Trooper Paul. You're going to put Trooper Paul back up there and have him go against ARCA again? I'm going to tell you, ARCA this time around, if we go to a retrial, probably going to be better prepared. Because now, what have you allowed the defense team to do? You've allowed to have them, they have allowed to have time. Now they can probably talk to ARCA. I would hope that they lead with them if there is a retrial. Let's get ARCA up there right away. Disprove all this crap. Let's show a demonstration video. All right, let me give you my bonus. The bonus. And who does it land on? Excuse me. Excuse me. Who does it land on this time? The bonus. The burden of proof is even greater for the Commonwealth. Adam Lunchbox Lally and Michael Meatball Morsi. The burden of proof is now greater this time around. And their case was horrible last time. I had people that weren't even really in tune with the case and just watched some of the bits of the trial, and they went, geez, are these witnesses on trial? Are these witnesses on trial? And just a little bit of update. I talked about this earlier in the show. If you go to LTL Media News, right at the bottom on the landing page, we have a link right to Karen Read's Defense Fund site. You can click on that and donate anytime. It will bring you right there. I have a lot of people that reach out to me and say, hey, do you have the defense link? Can I get the defense link? I want to make sure it's the right defense link. Just go right to my landing page, ltlmedianews.com. Right on the bottom, it says free Karen Read. You can click on that. It'll bring you right to the donation site. All right. That is my presentation. What I want to do in the second half of the show, let's talk about some of the awful witnesses. Let's go back and watch a little of the mini snippets of the testimony. We're going to start off, and we haven't talked about this person in a while. We'll start off with Katie McLaughlin, and she's going to talk about and try to get around and snake around her relationships with the Alberts when Alan Jackson questions her. Let's watch some of that testimony and watch her snake around this. Here we go.
Well, yes and
Thank you,
no. The statement was made in front of the police officer, so that would technically be the first time that statement was made to a police officer in my presence. And then, yes, I testified to it on January 30th, as you said.
You said it on January 30th. You weren't testifying under oath, correct?
Okay. Said it. Said it.
Okay.
Yes.
My question was really, and I appreciate you clarifying, my question was really the first time you actually told this statement to any law enforcement officer was on January 30th.
Yes.
Okay, we can take that down.
I also want to point out, you're going to see a lot of the biasness here, the hate for Alan Jackson that Judge Bev gives Alan Jackson. Watch the hate here. The hate. We're going to take this sidebar. You can take that down. Don't put that back up. Take it down. Watch.
That was when you met with Trooper Michael Crockett, correct?
Yes.
Obviously, that was very close in time to the event. It was the next day. Is that right?
Yes.
The events were close.
The 29th. Yeah. So it would be the next day.
Right. 29th, 30.
Yeah.
Okay. The events were fresh in your mind at that time.
Yes.
You obviously knew about the importance of that interview. You knew that it dealt with a police officer who had passed.
I knew it was important to talk to the police about what I heard.
And you wanted to be accurate.
Yes.
You wanted to be as detailed as you possibly could.
Yes.
And you understand that memories, obviously, they get a little worse with time, not better with time, right?
Sure.
The closer in time you are to the event, the fresher your memory is going to be about the details of that event. You would agree with that, right?
Sure.
You told Trooper Proctor the day after the event on January 30th that the statement that you attribute to my client was actually made to the female, not to you in response to your questioning. That's what you told Trooper Proctor, correct?
I don't have those notes in front of me, so I don't know that I can tell you that that's
Here we go. I don't have the notes. I can't recall. Can I see it? The same thing. What is the commonality here in all these witnesses? I can't see it. I don't remember. I don't have the notes. You heard that a lot with Jennifer McCabe. You heard it with Matt McCabe. You heard it with all of them up there. This is the strategy that they employed because they knew that all of everything that happened and then getting up here, my voice is cracking tonight, and then getting up here, it's all bullshit. They have to manufacture this story now in front of the jury. So they changed their testimony. I don't remember. I don't recall. This is all to throw the jury off. That's all this is.
Correct, but the statement was made in response to my question. However,
Exactly, Cheryl.
Miss Reed was looking at the civilian woman as she said that.
Does it refresh your recollection that what
Don't read what you think refreshes a recollection.
Exactly,
You can show
Sophie.
or you cannot read it. Yes.
They have the
Take a
worst
look.
memories on this planet.
highlighted portions back and forth? And look up when you're finished.
It's Katie McLaughlin.
Okay,
Ma'am?
sure.
You're on the
Yes.
camera. Does that refresh your recollection about what you told Trooper Proctor on January 30th?
Yes.
And you told Trooper Proctor,
No,
quote,
let her,
in turn,
hold on. I'll see you.
Here's the biasness. I'll see you at sidebar. Here. Let's just speed up for the interest of time.
quote,
Here we go.
may I, Your Honor?
Yes.
In fact, what you told Trooper Proctor was, quote, Karen then turned to her friend and stated, I hit him, I hit him, I hit him, I hit him. End quote. Correct?
Okay.
Is that yes?
Yes, if you're saying that's in quotation marks in the in that, then yes.
That's what's in the report.
Okay.
And I'm not, you don't have to agree with me. I'm asking yes or no questions. Not okay?
Yes.
Okay, thank you.
That's right, Heather. You're right.
So in fact, what you told Trooper Proctor was that Karen Reed looked at the female to your left and said 4 times, I hit him, I hit him, I hit him, I hit him, correct?
Yes.
And have you since learned that the name or identity of the female that was standing to your left?
No.
You're aware that the female that was standing to your left reported the exact same statement?
No.
Are you aware that the female standing to your left reported that exact same statement as, could I have hit him? Did I hit him? Did I hit him?
No, I'm not aware of that.
You then went back to the ambulance after you heard that statement that you believed you heard my client state.
Yes.
You opened the ambulance door, correct?
Yes.
That was the back door.
No, I was going back and I said this. Thank you for muted. Telling the truth shouldn't be this much work. Testimony shouldn't be this consistent, especially from first responders. So my question to you is in the chat, and let's get involved here. What 2 people, and I have them on my mind, what 2 people where testimony flowed off their tongue? Okay. What 2 witnesses in this trial, not experts, witnesses, 2 witnesses that their testimony flowed off the tongue because they had nothing to hide. They were not lying. I'll wait. We got one. Who's the other one? There you go. John's got it. Barrow and Lucky. That's right. You got it. Exactly. No, not experts. Witnesses, not experts. You all got it. John got it first. All right, let's keep going here.
Door,
The side door.
the side door. And there were 2 officers, I'm sorry, 2 firefighter paramedics in that ambulance at the time, correct?
I believe there were more than 2 at that time.
2 of them included firefighter
Barrows.
Nuttall and firefighter Flamani.
Yes.
And at that point, you told them what you believed you had just heard.
So I went into the back of the ambulance. I said, this is his name. This is his date of birth.
This is where it's going to
She
all
says he
wrap
doesn't
for
have
her.
any medical history or allergies, doesn't take daily medications. And then I said, she's saying I hit him. And firefighter Nuttall motioned to his face and said something.
Objection, Your Honor.
Ask another question.
So the answer to my question is yes, you told in front of Flamati and Nuttall the phrase, I hit him.
Yes.
You didn't write that in any report.
I don't write a report in this scenario of my job.
Let her finish the answer, please.
So there are two people that will write reports in my department on a call, one being the lead paramedic and the other being the officer who's on scene. So those are the people that write reports, and I was neither of those, so I did not write that in a report. That's correct.
So let me ask the question again. You didn't write it in any report?
No.
You didn't write it in any notes?
Nope.
No.
You didn't document that statement in any way whatsoever, correct?
Other than my interview with Proctor and my subsequent testimony.
You didn't document that statement in any way yourself, did you?
No.
Since January 30th, in that conversation that we just talked about with Trooper Proctor, your statement has evolved.
Yep.
Is that right?
I don't know how to answer that.
You testified yesterday to something quite different
Not quite different.
than what you testified, I'm sorry, than what you stated to Trooper Proctor.
Respectfully, I think my testimony has been pretty consistent.
You testified to something yesterday quite different in context than what you told Trooper
Keto
Proctor.
Jackson.
Isn't that right?
I don't know that that's right.
Well, you told Trooper Proctor, Karen Reed looked at a female standing to your left, said, I hit him, I hit him, I hit him, I hit him. Right?
Yes.
Yesterday, you told these jurors that Karen Reed said, I hit him. And an officer said, you what? And she repeated, I hit him. And the officer immediately turned and went to find another sergeant. Is that right or no? Yes or no?
No, there was more to that testimony.
That's
I
not what you
think.
said yesterday?
I think I said more than that, than what you just repeated.
Is what I said consistent with what you said yesterday? There's a lot of things that you said, more of. I'm asking, is that the sum and substance of what you
Right.
told these jurors yesterday?
Yes.
So you would agree that from that time till yesterday, your story has evolved. It's changed.
Yep.
Would I agree with that?
No?
I don't know that I agree with that.
You think the story that you told Trooper Proctor is exactly the same?
I understand what you're saying. So I understand what you're saying.
So has your story evolved?
Okay. Yes.
Okay.
There you go. Lies. You're adding stuff in. Changing testimony.
Ms. McLaughlin, who's Caitlin Albert?
Uh-oh.
I went to high school with somebody named Caitlin Albert.
Somebody.
Somebody named Caitlin Albert.
I love that. I went to high school with somebody named That's distancing. Let's just distance myself as much as I can. And then we saw all the photos that came out. You know, she said, oh, I know she's an acquaintance, didn't really hang out with her that much. And then literally after all her testimony, all these photos started to pour out with them being in very social situations together. And again, these are the Commonwealth witnesses. They're going to call these people back if we go back to a second trial and hear their lies again. And they're going to have to get them straight because they can't even do it here the first go around.
I went to high school with somebody named Caitlin Albert.
So do you know Caitlin Albert?
I do.
Friends with Caitlin Albert?
I would say more
Yeah.
acquaintances,
Okay.
not close friends.
How do you
Okay.
describe an acquaintance?
I would say that we have mutual friends, so we might see each other occasionally because of mutual friends, but we don't have a one-on-one friendship or hang out regularly.
Who's her dad?
I don't know.
Objections. Do you know who her family is?
Objection.
Sustained.
May we approach Val?
Yes.
It's the biasness again. She knows. She knows. And that cross, believe me, that cross ain't keeping any keeping you holy or any evil away. Believe me. It's not, it ain't working. We saw through. You notice that? What is it, like 3 or 4 of the witnesses, they all wore crosses. They all of a sudden became holy people and protectors of Jesus. And yeah, that was funny. Real funny. All right. So again, we're going to pull up the Commonwealth witnesses. People like Trooper Guarino. Doesn't know John O'Keefe's cell phone. Can't keep his report straight. Can't seem to coordinate things with Tully, all over the place. Well, let's hear from him.
Objection.
2022, Trooper Michael Proctor and Sergeant Yuri Buchanan of the Norfolk County District Attorney's Office responded to the unattended death of John O'Keefe at 34 Fairview Road in Canton. Those were your words, were they not?
All right. So the objection sustained. You can ask it differently.
Did Michael Proctor tell you that he had received or retrieved John O'Keefe's cell phone from 34 Fairview Road in Canton?
Objection.
I'm going to allow that.
No, I didn't know where it was retrieved from.
You didn't know where it was retrieved from.
Correct.
Guy knows
All right.
nothing either.
But you did include in your report that while Proctor and Buchanan were on scene, they retrieved the cell phone of John O'Keefe, correct?
At some point during the day, they did. I don't know where from. So
Right.
there's multiple.
Yeah, I'm asking about your report, Trooper. You know I'm questioning you about your report.
No, I understand. I'm explaining.
No,
I don't know what
You
scene
don't get
it's
to explain,
from.
sir,
Oh.
most respectfully, until Mr. Lally questions you.
Objection. Your
Okay.
Honor.
So no comments. I think to speed things along, do you have your report with you?
I do, Your Honor.
I think it'll make it easier,
Or
Ms.
can you read
Giannetti.
the first two lines? of that
Let
report?
him grab it.
Can you read the first two
Yep.
lines to the jury, please?
Yep. On Saturday, January 29th, 2022, Trooper Michael Proctor and Sergeant Yuri Buchanan of the Norfolk District Attorney's Office responded to the unattended death of John O'Keefe at 34 Fairview Road in Canton. Through his investigation, was found O'Keefe was a victim of a motor vehicle homicide. While
Let me pause this real quick. Lissy B, thank you so much. $8 Aussie will make it $8 American. Says now more than ever, we need to keep supporting Brian and our other justice warriors. Oh, thank you so much. I appreciate that. And I agree. I do agree. And I agree. Karen needs us more than anything right now. 1000%. She needs us more than anything. And we will continue to fight. We will be here. Like I said, earlier in the live, we're not going anywhere. All right, let's look at the liar, the guy that can't keep his report straight here.
scene, Trooper Proctor secured O'Keefe's phone and brought it to the Norfolk DA's office for forensic analysis.
Okay. So you'd agree with me that you included that clause, while on scene, they secured his phone, did you not?
I did write that.
Okay. And that was back on February 4th of 2022, correct?
Yes, it was.
Within 6 days of John O'Keefe being found mortally wounded on Albert's lawn, correct?
Kelly, thank you so much. $2 says, what a face to end my weekend with. Is that you're looking at the trooper or me? And it's just the beginning of the weekend. It's only Friday. But thank you for the $2. We'll add that up. I appreciate it. And let's keep going here. And if we can we're at 346 likes right now. Let's get
Yes,
to
sir.
500.
And at that time,
500 would be great.
You knew that the crime scene was 34 Fairview Road, correct?
No,
Yet you put in your report while on scene, did you not?
yes, I don't know what scene they recovered from. I know they went multiple places on the 29th. They didn't get back to me till 7:30 that night almost
Okay.
when I first got the
Well,
phone.
you'd agree with me that the Canton Police Department wasn't the crime scene, correct?
I never said crime scene in my report. I wrote scene.
Okay. Well, Canton Police Department was not the scene of any crime, was it?
I don't know. I don't believe so.
You don't know if the Canton Police Department was the scene of a crime. Is
I
that
don't
what
think it was.
You don't think it is? Okay. Now, in that report, you were trying to establish the chain of custody of that phone, right? Because you described where it was
Spirits
found,
tonight.
where it was taken, and who had possession of it, correct?
I said, it never said where it was taken. I said the phone was recovered on scene by Trooper Proctor. Again, I don't know where it was recovered from. I did find out later
Distance
it was at
ourselves.
Canton PD.
Well, hold on a second. Again, we're focusing on your report.
I know, I'm reading it.
As opposed to details you want to fill in now, okay?
Okay.
With regard to, you just testified that you never said where it was taken, yet previously you said it was taken to you, was it not?
No, I said recovered from, like the scene location.
Did Trooper Proctor take the phone
Tell
to
the-
you and
Yes.
hand it to you?
Story,
Yes, he
man.
did.
Okay, so it was taken to you, correct?
That is correct.
All right. So you described in your report where it was found because you said while on scene, correct?
Correct.
And where it was taken to you, correct?
Yes, sir.
And who had possession of it, which was initially Trooper Proctor in terms of your observations, and then you, correct?
That is who brought me the phone to the DA's office. Yes.
And you would agree with me that chain of custody of a piece of evidence is an important detail in any criminal investigation, isn't it?
Yes.
Exactly. $2. Where was the phone, homeboy? Exactly. That's what we're trying to get to here, sir.
Would you agree with me that someone reading your report or listening to it as the jury listened today would understand you to be saying that Michael Proctor seized John O'Keefe's cell phone at 34 Road in Canton?
Objection.
All right. I'd like to ask you some questions about the extraction that you discussed
Oh, this would
in
be
that
good too.
same February 4th, 2022 report, the very same report. In that report, after you name the tools that you use to extract data from the phone, you indicated that a copy of that cell phone extraction was placed on a state police server, or was it a DA's office server?
DA's office server.
Okay, on a server so that it could be accessed there, correct?
That is correct.
But that extraction you placed on the server did not include all the potential data on John O'Keefe's phone, did it?
How do you mean?
Well, didn't you indicate in your report that the extraction was not inclusive of all potential data contained within the device?
No, that's not true.
Well, the extraction that you did contained communications, iOS messages, phone calls, social media communications between John O'Keefe and Karen Reed, correct?
Yes, that's correct.
And it contained communications between John O'Keefe and Jennifer McCabe.
Yes, that's true.
It contained communications between John O'Keefe and Kerry Roberts.
I can't recall.
All right. But it did not include any communications between John O'Keefe and Julie Albert, did it?
Again, I can't recall.
And again, I'm talking about that initial extraction. That initial one didn't include any communications between John O'Keefe and Chris Albert, did it?
Convenient.
I
huh?
only created one extraction of John O'Keefe's phone.
That extraction report also did not include any location data, did it?
Very convenient.
No, it did.
You didn't note any location data in that initial report, did you?
In the February 4th report,
Correct.
I didn't go through the data at that point.
All right.
This is just my extraction report saying that I got the phone, it was extracted and placed onto the server. And then I wrote, this report is not inclusive of all potential evidence, potential data contained within this evidence.
When was the first time that you reported on location data in this case?
I don't remember.
Wasn't until April of 2023, correct?
There was a reason for that.
Well, I didn't ask you if there was a reason for it, sir. You understood my question, didn't you?
That's correct. My first report regarding was in January.
Here we go. You have a police officer laughing at the defense attorney asking questions on cross, like snarky, just laughing, because they know they're all lying and like, just being brazen about everything. You're not going to get me, having that attitude. You're not going to get me. I'm smarter than you. Oh, you think you're going to ask these questions and question me about my my detective work, when I extracted phones, when I put location data into reports.
Anyway,
And
Snarky.
we're talking about John O'Keefe's phone now here.
Yeah.
You did not report on the location data on John O'Keefe's phone until April of 2023, correct?
I didn't look at the extraction initially.
And you also did not report on any Apple Health data until the spring of 2023, correct?
Again, I didn't look at the phone extraction. Trooper Proctor would have looked at it. I would have loaded it and given it to him.
Okay, so
Great.
Trooper Proctor had access to the phone first, and then you took care of it, correct?
He had access to the extraction that I would load onto Cellbrite for him to look at, where you can't change the data. That is correct.
And you would agree with me that you didn't address John O'Keefe's health or location data in any formal report until that April 23 report, correct?
That is correct. I never went through it.
Right, and you submitted your report in April of 2023 after you became aware of an affidavit filed by the defense expert, Rick Green, in which Mr. Green extracted and analyzed John O'Keefe's location data and his movements according to Apple Health data. Isn't that correct?
Yes, that is correct.
Before Rick Green submitted that affidavit, no member of the state police homicide investigation team, including you, had ever looked at or at least reported on the location data for anyone present at 34 Fairview, correct?
For the devices that we had, sir?
For John O'Keefe's device,
Yeah.
For Jennifer McCabe's device, etc.
I can't speak to that. I don't know.
All right, but you didn't, correct?
Again, I didn't look at the extractions until later.
Right.
So like I said, these are the witnesses that the Commonwealth is going to put up there in front of this jury again. And they're going to change their story. They're going to lie. They're going to say, I don't remember. They're going to say, I don't recall. I need to look at the report. They're going to be snarky. You know, it's almost like we're untouchable. You're not going to get us. You know, you're not going to get us. We're the ones that are untouchable. Who do you think you are questioning me? All right, let's look at another beautiful witness for the Commonwealth. And I'm pretty sure he's not going to get called the second time around if we go to another trial, is Trooper Proctor. Let's look at some of his testimony. And probably, I got Jennifer McCabe up there as my worst, but I mean, this guy here is just a piece of trash. Pure trash. All right, let's go here.
A person by the name of Doc writes, is that chick a smoke? Correct?
Correct.
Who's the chick?
Misread.
And you write
I am so blind now.
EH, right?
This is bad.
Yes.
And then you
I
write,
knew this was going to happen. The minute I got glasses and started wearing them, I said, my freaking eyes are going to adjust to them. And now I need to like wear them all the time. I can't read anything anymore. Oh my God. Don't get old. It sucks. All right, let's go back to Proctor.
nutbag, as Chief would say, correct?
Correct.
Who's Chief?
A friend of mine.
I can literally not see anything anymore. Sucks.
And then you write what?
She's got a leaky balloon knot.
Trooper Proctor, explain to the
As a
jurors
scumbag.
what a balloon knot is.
Your essentially, I guess, your rectum area.
Your anus?
Well, I'm old, Michelle.
Yes.
That's what you were
I am-
referring to about Miss Reed?
Yes.
And you were making fun of her because you believed at that time that it leaked? That's how you were treating Miss Reed? Yes or no?
Yes.
And then you followed that up just to make sure you cleared up any mistake about what you meant with leaks poo, correct?
Objection.
All right, so I'm going to strike that. You could get this in, but do it the right way, Mr. Jackson.
This is probably, I'm going to say, out of all of the testimony, you know, and listen, I've heard some vile testimony in trials. I've listened to a lot of trials, okay? This is some of the most vile, testimony, vile things that someone has ever done. I mean, I can deal with the blood and the guts and all that. But when you degrade, especially a woman that has a medical issue, that you're now talking about this, and this is going to be broadcast to the world, you know, mentally, what that does to someone to put that out there. I mean, it's so personal. It's like someone breaking into your house and touching your things or laying in your bed. You know, you would feel so violated by that. I don't care if you're a man or a woman, how violated you would feel about that. How violated you would feel if you're, you know, even a man sitting there and listen to someone talk about you in this way. That is now broadcast for the world. This is a disgusting, repulsive person. And I've said this before. This is not the first go around with this guy. He's done this before. He's talked like this before. It's sick behavior that's inside this guy's head. He's dirty. This is a very, very dirty cop. And if he's talking like this, then what physical things is he doing in investigations? Is he, you know, not writing reports, falsifying reports? Are we doctoring Sallyport footage? Are you doing this in other cases? Planting evidence, hiding murder weapons, placing murder weapons in other places? Having conversations like this with other people, your friends, your family members, your colleagues, your superiors? Pretty disgusting stuff. John, thank you so much. 5 gifted memberships. Welcome in new members. And we'll add a 25 spot to the total tonight. Yeah, Tessa, all of the above. And not only, my voice cracked. Not only is he doing this in his professional life, guess where else he's doing it? Guess where else he's doing it? In his personal life. There's no rules in his personal life. There's no rules in his professional life. This is who this guy is. And he should never, ever, ever, ever serve his community ever again. This guy needs to go somewhere and bury his fucking head in the sand. You're done. What did Scarface say? Dress warm because you're going to be living in Alaska. That's where he needs to go. Needs to go to Alaska. See you later, buddy. All right, let's keep playing.
You followed that up with the phrase leaks poo, didn't you?
I did.
Again, another reference to Miss Reed's medical issues and medical conditions, correct?
Correct.
Specifically focused on her anus, correct?
Scumbag.
In reference, yes.
Were you aware at the time that you wrote this that Miss Reed had suffered a colectomy surgery, very serious surgery?
Just go through this real quick. Kat Randall, thank you so much. 2-month membership. Thank you for supporting the channel. Says thanks for pushing this hard road. Thank you. Thank you. No, thank you for being here. Because like I said, these channels, this channel, LTL Media does not run without the subscribers here, the people that support these lives. And I am very appreciative. Thank you. All right, let's go.
I was not, sir, no.
Were you aware that she had had 10 surgeries in 18 months, several years prior? 10.
I was not aware of that.
Were you aware that she had serious medical issues, gastrointestinal medical issues that she suffered with, she was a victim of for years? Did you know that?
Objection.
Sustained.
But you decided that you're going to take another shot at her and talk
Crystal,
about
thank you
her
for the 5
anatomy.
gifted memberships. At a 25 spot. Thank you. Thank you, Jody. Appreciate that. Thank you, Sophie, for keeping the total. I appreciate it.
I'm sorry. You decided that you were going to take another shot at her and talk about her anatomy.
Real quick, and I'm sorry, I've paused this a lot, and I know people get upset at me on the replay. I'm just going to let you know right now. This is a live show. I interact with the chat. I will read super chats or gifted memberships because I owe the respect back to the people that have pushed that button to contribute. So I will stop. I will commentate. It's called fair use. Just want to get all those rules out of the way. And I just lost my train of thought. Oh, what I was going to say, if you were gifted a membership, this is how it works. Gifted memberships will allow you 1 month free to my members only content. That is on my homepage. You scroll all the way to the bottom, you will get invited into members only lives, and you can go watch previous content. Now, my memberships range from like $2 all the way up to $100 a month. The gifted membership is a $5 membership. It's going to give you access, and that just comes out monthly. It's like a monthly contribute like a subscription. All I ask you this, if you've been gifted a membership at the end of the month, if you can just re-up it, and you don't, I get it. $5 right now could possibly be a lot of money to people. I get that. That's the world we live in now. But if you want to re-up that subscription, you can go right down to the $1.99 and it will still offer you members only access. And $1.99 is like literally less than probably a Starbucks coffee now. And if you could do that, it helps keep the lights here on the in the studio in LTL Studios. I would appreciate it. Oh, wait, let me just get this. $5 says, do any of these witnesses know that if you're not a McAlbert, they have no loyal to them and they'd stab you in the back to protect each other? And we saw that. Oh, wait, we saw that through this entire trial. The lying, the changing of testimony, what they said to the grand jury. Now they're going to lie in front of the jury. I mean, you saw that in Jennifer McCabe's testimony. That was pointed out by Alan Jackson probably 5 or 6 times. In Jen McCabe's testimony, and I agree with you 100%. All right, let's get back to Proctor.
As a balloon knot, correct?
Objection.
Sustained.
At this point, Trooper Proctor, Miss Reed was just reduced to a punchline to you, wasn't she?
Objection.
Sustained.
Well, you weren't done yet. This chat doesn't end yet, does it?
No, sir.
Let's skip to 2543.
It
On the
does
same
keep
day,
ghosts
February
away.
2nd, 2022, about 4:15 p.m., a person by the name of Whitey wrote, "What are you guzzling on?" Correct?
Yes.
And you wrote, "Nothing, writing a warrant." Is that right?
Correct.
Whitey then shares some sort of a video, correct?
Yes.
You remember that video being of the 1980s band Warrant?
I don't recall the video he sent.
0095 laughed and then wrote, "Wait, why does her asshole leak?" Correct?
Yes, that's what he wrote.
Real quick, just get this in. John, thank you so much. Thanks. $40. Wow, thank you. Appreciate that. $40 just came in from DW. Sorry about that. DW screen names. I feel like we're back in AOL, right? We talked about this the other day. But DW, thank you so much. Says thanks for your continued efforts, Brian. Great flashback show. Yeah, you know, we've been doing these. And the audience has really liked it. We went through Jennifer McCabe. We went through Trooper Paul. I want to start to get into some of the other testimony. Higgins, Albert, we'll go through it. And, you all, like I said, you all call for it. You all make the chats go. I don't mind doing it. We'll continue doing it. It's not a problem. Thank you so much for the contribution, though. Appreciate that. All right, let's go.
And then what did Doc write in response to that?
Objection, Your Honor.
The objection sustained. I'll see it. Sidebar, take that down, please.
There you go. There's the biasness Bev. All right, I'm going to speed up for the interest of time here. Interest of time. All right, here we go.
You are unmuted.
Yeah, I agree, Sabrina. That's why we've been doing this.
Without
that-
reference to-
Take that down.
Is the unbiased, the
Without
biasness
reference to
Bev.
the specifics of what was.
I'm going to see counsel at sidebar.
Again, biasness Bev. Bias Bev. Let's speed up here. Here we go. Sidebar.
Trooper Proctor, without getting to the specifics of the words used in the following, in the next exchange that you're looking at, it's fair to say that your high school buddies then continue to discuss Ms. Reed's medical issues, correct?
Objection.
Thank you.
That's sustained. Come on, Mr. Jackson. That isn't what you said you'd ask. Go ahead and ask the question you said you'd ask.
Was there a continued discussion that finished on this subject matter?
Yes.
On Monday, you indicated that your conduct in this case, and specifically your conduct as reflected in these messages, how did you put it? It did not affect the integrity of the investigation, of your investigation, correct? That's what you
Correct.
said to the jurors.
Correct.
So he's trying to state that his conduct in this case did not affect the investigation at all. Are you serious? You're going to roll with that. You're going to roll with that. The way that you spoke about Karen Reed, the way that you investigated this case, the way that you collected evidence, the way that you talked to witnesses, the way that you didn't follow procedure, you're saying it didn't compromise anything in this case. Okay.
Do you know what the definition of integrity is?
Doing the right
Right.
thing when no one's looking.
It means the quality of being honest and having strong moral principles, correct?
Objection.
Sustained.
Do you believe that integrity means being honest and having strong moral principles?
Right.
I believe that's part of it as well.
Pot him in.
Do you stand by that testimony that you were showing strong moral principles in this investigation, sir?
In the investigation part, absolutely. Through these text messages, absolutely not. They were juvenile and regrettable.
Sure they were, pal. I'm sure that's really how you feel.
When you say they're juvenile and regrettable, sounds like you're almost apologizing to the jury
Yeah.
for your conduct. Is that what you're doing?
For those text,
Objection. Your Honor.
Sustained.
Trooper Proctor, have you ever apologized to Ms. Reed?
Nope.
Objection.
Never will.
As the lead investigator in this case, you were tasked with the responsibility of making sure that the investigation remained free of any conflicts of interest. It's part of your job, correct?
correct.
Throughout the pendency of this investigation, in this case, you've denied having any conflict of interest in this case. Isn't that right?
Correct.
In fact, a couple of months ago in February of 2024, you testified in a different proceeding. Is that right?
Yes.
And you testified under oath in that proceeding on February 1st that you did not know any members of the Albert family or McCabe family, correct?
Certain members of the Albert family I did not know. I know Chris and Julie and Colin. I don't know the McCabe's.
That wasn't my question. Did you testify? Let's take them one at a time. Did you testify under oath, same oath you took here
Oh,
today,
we'll bring him back, Sabrina.
in a former proceeding in February of 2024 that you did not know and did not have any relationship
They'll bring him
with
back.
members of the Albert and McCabe families? Did you?
I haven't had a chance to review those minutes. I've only had one opportunity to, and that was a couple months ago. So I would want to review those minutes in order to answer that accurately.
You can't remember how you testified, whether or not you knew or had relationships with the Alberts and McCabe's?
Objection.
Sustained.
As you sit here right now, you need to refresh your recollection. You can't remember what you said.
Objection.
Do you remember what you said?
During that proceeding, no.
Of course not.
Would it refresh your recollection if you took a look at those grand jury minutes?
Yes.
Of course. Gotta get the story
What
straight,
page,
right?
Mr. Jackson?
This is page
Keep the lies
01563.
Excuse me.
If I may have just a moment, Your Honor.
Yes.
Now, Your Honor.
Okay.
Would that refresh your recollection about a question and answer that you had, or a series of questions and answers that you had while you were testifying under oath in that other proceeding?
Yes, sir.
Objection. May we approach?
Yes.
Of course. Of course. This might be it. Yeah, that's it. That's Trooper Proctor. All right. Let's end with one of my favorite ones of all time, the reconstructionist, the crime scene whisperer, Trooper Paul. This is the witness. This is the expert that the Commonwealth is going to rely on the second time around. If we go to a trial, this is the guy they're going to put up. This is their guy. And he's going to talk about reconstructing the accident scene. He probably can't even spell crash. He probably couldn't even spell expert. But this is the guy that the Commonwealth's going to throw up there and say this is their expert. Let's get to Alan Jackson asking Trooper Paul about his recreation and his scientific explanation of what happened the night at 34 Fairview.
Regulations are inapplicable, right?
I'm saying it would underestimate the speed and the distance.
The truth is, Trooper Paul, you have no idea what all these physics calculations mean, do you?
Objection.
Sustained.
You've not been trained in physics formally, have you?
Yes,
You have been,
it's incorporated into the classes.
right? You had a few classes that used the word physics, but you haven't been formally trained in physics, have
Objection.
Sustained.
you? You haven't been formally trained in kinematics, correct?
It's in the aspects of all our crash reconstruction classes.
You haven't been formally trained and hold no degrees in biomechanics, do you?
I do not have a degree in biomechanics.
In fact, basically what you did in this case was calculated emission cycles. And you got those wrong, right?
Objection.
Sustained. Come on, Mr. Jackson. Ask the appropriate part of the question, you'll get it.
Bias Bev again.
Let me ask you this. Based on your reconstruction, nearly 2-year investigation, exactly how was that taillight shattered?
Here we go.
Explain it to us.
How does the taillight, what do you, it gets, so the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
Based on what I saw for his injuries was from the upper part of his arm down.
Was his arm out? It just struck the arm like a hinge? Was it in front of him? You did the reconstruction?
It looked,
Here's exactly how his body was positioned when he was struck by that.
so it looks like his arm was more kind of like this. If I can try to get that.
You're indicating out by his side, correct?
Yes,
And the taillight would have struck his arm, right?
yes,
Not his torso.
yes,
Okay. So the full mass, the full weight of that truck hit him basically at the elbow. Is that right?
No,
Missing his
no.
torso.
but I said it, yeah, from the upper part of the arm
Right,
down.
that-
Yeah.
that elbow and the biceps.
I didn't see anything that shows an indication that this lower torso was struck, but
Okay. So his torso.
it's not saying it could not have been a possibility, but I just didn't see anything.
So his torso was spared from being hit, but the arm took the brunt, the full force of the vehicle, correct?
Like arm and shoulder. Yes.
And you said he then did a spin,
Oh,
like a sort of a pirouette.
oh,
He got spun around possibly the way he struck. It looked like it could have turned around counterclockwise.
Okay. So if he turns around counterclockwise.
right, here we go.
Is he turning around in the air counterclockwise?
Here we go.
Yes. Initially.
So he gets hit on the upper biceps, shoulder area, and down to the forearm
Here it
Right.
comes.
Yes.
by an unbroken taillight, right?
Yes.
In other words, it's nice and smooth. No shards of plastic or anything broken at the time that it made contact with his arm, right?
Correct.
Okay, so how does his arm get all cut up?
Because when his arm
Look at Jackson
struck the
smiling.
tail light then cracked. And as the car is driving past him, the tail light could scratch it.
Got it. So he gets hit by the car, not his torso, just the arm.
Here we go.
Taillight cracks, and as it passes by, his arm stays with it long enough to get
This is so
striations,
ridiculous.
those scratches that you see, those lacerations. I'm sorry, those abrasions that you see, right?
In a sense, yes.
And at the same time, he does a pirouette and flies 30 feet. Goes by the point breast.
Oh, it's
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise. I don't know how far he ran counterclockwise, but he started rotating. According to that, would push him to rotate counterclockwise. Whether or not he went counterclockwise all the way to his back toward the ground, it seems like a most likely possibility.
Did you account for the fact that his arm is on a hinge?
Is what? Say again?
Did you account for the fact in this scenario that you just told the jurors that his arm is on a hinge?
On a
Called his
hinge.
shoulder?
He doesn't. On a
Okay.
hinge, what?
Okay, so arm got hit. Didn't his arm just swing?
Right.
I said arm and shoulder area, so his arm could have been considered part of it.
Even if his shoulder got the upper,
Okay.
you're pointing to his upper biceps.
Mhm.
Right? There's no injuries on his shoulder, not a single one, not even a bruise, right?
Correct.
Like I said, it looked like to me it was from up here. I don't know how far I can up back here, but it was up here.
Well,
So
you're the one that talked about his injuries on his arm.
yes.
That's limited to about mid biceps, to about mid forearm, correct?
Correct.
Okay.
Right?
Yes.
No injuries on the shoulder, no injuries on the torso, no injuries on the ribs, no injuries on the back, correct? Is that right?
Yes.
So your theory is you got hit on the arm, took the brunt of the force from the taillight on the arm, stayed with the vehicle long enough for the taillight to explode, basically, to shatter.
Essentially, yeah.
And
Explode.
these striations get on his arm, abrasions. Does a pirouette, spin, counterclockwise, and flies 30 feet in the air to his point of rest.
Yeah. It happened probably a little faster than that, though.
Oh my God.
Actually said he hit his head on the curb.
I said that's one of the possibilities of when you look at the roadway as he gets spun around counterclockwise. It's a possibility that the curb is there, any blunt force object on the ground, as the ground is pretty blunt.
Well, except in your scenario that you just told us, he flew through the air onto the light dusting of snow, grass, and dirt.
I didn't say through the air.
Say that again?
I didn't say he got thrown through the air.
Okay, I'll use your word. He got projected. Like
Projected doesn't mean it's not incorporating just throw. Project just means you
Oh
get pushed
my
forward.
God.
There's
So painful.
two parts of that. There's the air, then there's the ground. Like I said earlier, the tumbling, the rolling, whatever that part of the crash would happen. Projecting is just what we call what happens to a pedestrian post impact with a crash.
Okay, so a couple questions.
This is so bad.
If his arm, elbow took the brunt of that entire impact, how do you account for the fact that he didn't suffer a broken bone?
Right.
I don't know.
How do you account for the fact that he didn't have a fracture?
Right.
Objection.
That's our point.
Sustained.
How do you account for the fact that he didn't even have a bruise on the arm?
Objection.
That's sustained.
Fair approach.
Yes.
Unreal. That's who they're going to roll with. It's the Commonwealth wants. Kelly, thank you so much. $5. Super Trooper Paul recreation. I now do an interpretive dance. I think my husband thinks I've lost my mind, especially when I pirouette and tumble. I love that. I love that. I love it. All right, everybody. Tonight's going to be a short show. What I'm going to do, though, I'm going to spend a little time with members tonight. And if you are a member, I will drop the link in the chat. You can go join us immediately after the stream ends. And you can just click on that link there, and we're going to do some members only. I have a video that I want to go through, what is literally, I think, probably the most obnoxious woman that I've ever seen, basically arrested. And we can talk about that on the members only content, on the members only stream. So if you're not a member and you want to join us, you can start a membership. Just go down there and hit membership. Membership start at $2 and you'll be able to go over and join us. John, thank you so much for the $5 Aussie. We'll add that to the total. Says Trooper Paul is on the linear path of reconstruction expert, a part-time janitor. I love it. And we'll add another $5 here. Kat Randall gifted 1 membership. So we'll add $5. So hopefully we can get another total here before we close it up. And then we'll do the math for the Karen Reed's Defense Fund. So like I said, if you want to join us over in members only, you can click on that. You have to be a member to go in there. And you can follow us on over. Is right after the stream. We'll hang out a little bit in members only. I haven't done a members only in a while. So I'm just waiting to see our new total. And then I'm going to close this up. We'll close up shop and go over to members. All right. We're at 244. I'll round it to 250. 25% we'll get to Karen Reed at 62. We'll make it 65. 65 to Karen Reed tonight. I'll get that donated. I'll post up the receipt on Facebook and on the YouTube community page. All right. We're going to head over to the next stream. Again, I'll drop it in there for members. Come join us. We're going to hang out over there a little bit for members only content tonight. I thank you for watching this presentation, this show. Make sure to like, share, and subscribe. Let's get this to 1,000 likes. 1,000 likes. I would appreciate it. And this will round us right up to the 65. Pilgrim Shadow, thank you so much. Coming a new member. All right, I'll see everybody over in the members only in about 5 minutes. Again, click on that link. Get over there. Come hang out with us. And we'll have some fun over in members only. All right, I'm going to head out. Everybody have a great Friday night. If you're not going to follow over into members only, if you are, I'll see you there in a bit. All right, everybody. Thank you so much for supporting me. Take care. Bye-bye.